attention to where he was working by failing to report his alleged injury to the coordinator and by failing to make use of medical services that we have provided. The agents of my client did all that was necessary, and as such, I raise the defense of volenti non fit injuria. That is all.
I'm going to put a little emphasis on the volenti non fit injuria. Directly translated as to one who is willing, no harm is done. Is a defense in tort that means where persons engaged in an event accept and aware of the risk inherent in that event. They cannot later complain of or seek compensation for an injury suffered during the event. This is used often as a defense against tort actions as a result of sport injuries, as in this case, where he voluntarily acted in the midnight.
Thank you. I shall now deliberate. With respect to the question of whether Mr. Gabriel consented to participating in the event, I give my verdict as such. The court considers the state of mind of this claimant on the day of the incident. He was a new employee on contract, enthusiastic to make a good impression. He arrived late and his superior suggested that he should participate. In those circumstances, the court finds that the claimant participated out of a feeling of obligation as a junior employee of the company. With respect to the question of whether Mr. Gabriel knew of the risk involved, my verdict is as such. It is obvious that no instructions were given and possibly demonstrated to potential participants. This court therefore is of the view that the claimant was not fully aware of all risks involved, and so he could not have consented to undertaking those risks of which he was unaware. The court believes that the person to give evidence on behalf of the defendant was the event coordinator. Remarkably, neither she nor anyone who formed part of a team was called to give evidence. This rather glaring omission resounds to the detriment of the defendant's case. Now the defendant opposes the claimant's case on the basis of volenti non fit injuria. Had such evidence been given, it would no doubt have added to the strength of this defense. Under these circumstances, this court finds that the defendant has a duty of care towards the claimant, has a duty of care towards the claimant, and the defendant failed in that duty. Consequently, there shall be a judgment for the claimant, and damages will be awarded in the sum of $450,000 with interest of 9% per annum. Can we move on to the next case, please? Trying to stick this time.
High Court assignment number 3 of 2004. Honorable Madam Justice America Tuwale Reddy presiding. Parties involved, Madam Lucaran Dabin, plaintiff, versus the Port Authority of Trinidad and Tobago, the defendant. Here you go, Madam.
Thank you very much.
Your Honor, my former employer, Port Authority of Trinidad and Tobago, has refused to treat with me fairly and respectfully. What? Your Honor, is disturbing me.
Order in court. Order in court.
He refused to treat with me fairly and respectfully what should have been my confirmed post as a daily paid worker, as well as remuneration since my release from the state penitentiary.
How do you, oh, sorry.
How do you reply? Your Honor, this individual was not in the country at the stated time, and we have an application form here.
No, sir.
Give it to him, please. For the withdrawal of this matter, from the High Court. This is clearly a matter for the court.
right? Workers' Compensation Act. In the U.S. Workers' Compensation Act, work files claim with state agency and benefits vary by state. They are paid according to present limits established by statute or regulation. An exclusive remedy prevents employees from suing employers for damages except for intentionally hurt by employer.
Your Honor, I have proof that I was in the country at the time when this madman made his statement, right? Your Honor, I also have proof that another person who also spent time in jail was reinstated into their former position. The union was refused to take my side.
Are these all the documents, sir?
Yes, Honor. Your Honor, these claims are absurd.
In Trinidad and Tobago, matters of employment can be taken to the High Court, where there is no union to represent or take the matter to the Industrial Court, under Section 51-1 of the Industrial Relations Act, IRA, Chapter 88-1. The claimant bears the responsibility of proof and mala fides. The claimant must show that he or she was treated unjustly in relation to someone else whom was in a similar circumstance. The reasonability of mala fides is to prove that the treatment meted out was actuated by malice. This is to adopt from the case Attorney General versus PC Confectionery Limited, 1985.